Thank you very much, Ariel. I want to thank Professor Nili Cohen for inviting me to address this topic. And it's a special privilege to me to discuss this topic in the presence of my teachers and mentors from the Hebrew University Faculty of Law, Morai V'Rabbai, Professor Claude Klein and Professor David Kretzmer. So I will address three dimensions, three legal dimensions that I would suggest the Balfour Declaration offers. The first one relates to the role of Britain as the mandatory power. The second relates to the significance of the declaration in the domestic legal systems of mandatory Palestine. And the third is the significance of the declaration for the establishment of the State of Israel. The first question is, what is the legal significance from the perspective of international law of the Balfour Declaration as a standalone document? Here, the question is whether it's legally binding, and we've heard the Palestinian claim that it has no significance whatsoever, because it's a document that was kind of a promise, a vague promise given by a country that had no sovereignty over the area when, and never had sovereignty over Palestine. There is one argument that was presented at the time by Professor Nathan Feinberg from the Hebrew University Faculty of Law, invoking the idea that the declaration is legally binding as an instrument in international law that, according to the doctrine of international law, binds the state that promises, that issues the declaration, to stand and promote and fulfill the obligation to the promisee. And the question is whether the Jewish people at the time had standing to be the recipient of a promise, because as you can see, in international law, at least at the time, and in this context even now, only a state can be a promisee of such a declaration. This is the argument. I will not delve into it and discuss it at length. It's an argument that has been made, and it has its strengths, it has its weaknesses. It's not clear, as we know, what the promise, if it is binding, what it consists of. And I think this is an argument that is less interesting than the following one. So I will address what I think is the more important and more critical claim, that the iteration of the Balfour Declaration in the letter of the mandate, in the mandate for Palestine, is the most significant point in terms of the legal the legal status of the document of the Balfour Declaration in international law. So the idea here is that the mandate for Palestine was a commitment of the mandatory power as a trustee of the entire international community. The League of Nations at the time is almost regarded as a synonym to the international community. And although the US is not part of the League of Nations, the US subscribed to the Balfour Declaration both in terms of its domestic law and in terms of its agreement with England. So, we have this statement by Georges Sel, a famous French international lawyer at the time, who regards the League of Nations as reflecting in the international community, and he proposes that all states are bound to respect whatever the League of Nations is committed to, including the mandate system. So from that perspective, the mandate system and the specific letter of mandate to the British, to Britain, are an international document that binds the UK towards the rest of the international community and binds the international community to accept the letter of mandate as reflecting positive international law. So, and the most important point in this context is that the declaration, the Balfour Declaration, is incorporated in the mandate and therefore becomes binding. It is part of the explicit authorization and obligation that is expected from the UK to ensure. So according to Article 22, Section 5 of the Covenant, whatever is stated in the letter of mandate is the relevant obligation and the relevant authorization that the mandatory power has to pursue. Now, let's see what the declaration says, and let's see what the letter of mandate says. That there are important differences between the Balfour Declaration and its iteration in the letter of the mandate. So, where the declaration calls for the establishment in Palestine of a national home for the Jewish people. It's being clearly understood that nothing shall be done which may prejudice the civil and religious rights of the existing non-Jewish communities in Palestine. So this is the text, at least part of the text of the Balfour Declaration. Let's now see the way it is incorporated in the letter of the mandate. First of all, we have in the preamble of the mandate for Palestine an explanation for the commitment of Balfour. The declaration reflects recognition to the historical connection of the Jewish people with Palestine and the grounds for reconstituting the national home in that country. So this is the logic. This is the underlying rationale for the Balfour Declaration that did not exist in the declaration. And now let's look at the specific provisions. Article 2 refers to the establishment of the Jewish national home and development of self-governing institutions, and also safeguarding the civil and religious rights not only of the non-Jewish communities, but all of the inhabitants of Palestine, irrespective of race and religion. And this will become important, as you will see, surprisingly important. There is reference to an appropriate Jewish agency that will be involved in advising and in promoting and establishing the Jewish national home, and there's an understanding that the Zionist organization shall be recognized as such agency. So it's clear, I would suggest, that the Zionist agenda of the Zionist organization was very much in the minds not only of the UK, but of the League of Nations. There's a commitment to facilitate Jewish immigration and close settlement by Jews on the land. facilitate the acquisition of Palestinian citizens by Jews who take up the permanent residence in Palestine. English, Arabic, and Hebrew are official languages. Now, Article 27 is important in the sense that the consent of the Council of the League of Nations is required for any modification of the terms of this mandate. And what this actually suggests that the letter of mandate is not a simply, not a treaty, a simple treaty between two consenting parties. It is an authorization, it is a constitutional text between the principal, the League of Nations, and the agent, the UK, to promote and to fulfill and to be obedient to the provisions of the letter of the mandate. So in terms of governance, the mandatory power is subject to the review of the Council of the League of Nations, to the review of the Permanent Mandate Commissions, and other states could bring the UK before the court, before the Permanent Court of International Justice, if they have any dispute about the fulfillment of the conditions of the mandate. So I would suggest, and this, I think this is, as much as lawyers can say, it's beyond dispute, that from the legal perspective, under international law, what is relevant in terms of the commitment of the UK as a mandatory power is the letter of the mandate, and whatever policies the British government has changed over time do not count legally. The white papers and other documents and other statements that were issued subsequently have no legal relevance. And I'll briefly mention the different reiterations of or reinterpretations of the Balfour Declaration in the various white papers, and we see a shift, incremental shift away from commitment to the Zionist goal. First of all, in 1922, the government does not contemplate that Palestine as a whole should be converted into a Jewish national home, and Palestine may become a center in which the Jewish people as a whole may take, on grounds of religion and race, an interest and pride. Some beginning of maybe withdrawing, or for certain audiences to appease their concerns. Then in 1930, the Pasfield White Paper, we see an attempt to find equal grounds, equality between the two communities. In 1939, the shift towards the Arab community. They have veto. There's nothing will be done against the will of the Arab population in the country, and all the restrictions that we know about immigration and about purchasing lands. All these white papers and other documents have no legal validity in terms of international law. What continues to be binding is the interpretation, is the Balfour Declaration, the way it was interpreted and incorporated and enhanced in the letter of the mandate of 1922. And here we have with us Professor Susan Pedersen, and her chapter 12 of her book, The Guardians, describes the ongoing tension, contestation between the mandatory power and the Permanent Mandate Commission. The Permanent Commission, reflecting on the 1939 white paper expresses implicitly a disagreement, or they regard, the whole committee regards the white paper as not in accordance with the interpretation which the Commission has placed upon the Palestine mandate, and 4 out of the 7 members say that they did not feel able to state that the policy was in conformity with the mandate. Now, what is the political significance? We can argue about it. We know that it might be irrelevant what the permanent mandate commission would do, especially in 1939. The war starts, but the point, I mean, I'm addressing the legal point, and here, what you see here is that whatever the British government is doing is subject to review, based on the idea that the British government, as a mandatory power, is simply an agent of the League of Nations. So this is with respect to the first aspect of the legal significance of the declaration. And now I would like to move to the second significance, which is the domestic law, the domestic legal system of Palestine. So it turns out that in 1922, the Palestine Order in Council is promulgated. So this is the main legal document, the foundational legal document of the legal system of Palestine, and that Order in Council incorporates the declaration verbatim, but also incorporates the mandate. So the idea is that the government of Palestine is subject to the provisions of the mandate. Article 18 suggests that no ordinance shall be passed which shall be in any way repugnant to or inconsistent with the provisions of the mandate. Moreover, Article 89 suggests that all subsequent orders in council shall also be in accordance with the mandate conferred on the British king. So there's a quite strong commitment to the mandate, and thereby also to the Balfour Declaration, as part of domestic law. And what is the significance of that? We see immediately in 1925, in the dispute concerning the diversion of the waters of the spring of the Utas village near Bethlehem. The idea was, at the time, was draft in Jerusalem, and the community had little access to water, and so the decision was to divert water from the spring, from the Arab village, to the pools of Solomon, and through that to Jerusalem, to serve the needs of the people in Jerusalem. The landowners, realizing that they have not enough water for agriculture and to feed and for the cattle, they petitioned to the court and invoked the Balfour Declaration and invoked the commitment to safeguarding civil rights. And the Palestinian High Court finds that the Balfour Declaration and the mandate for Palestine as such have no legal status in the law of Palestine. But it is the Order in Council which incorporates the mandate and incorporates the Balfour Declaration and the Order in Council is the document that requires the court to scan the mandate in order to see whether an ordinance which is attacked before the courts does in fact sin at all against the mandate, and if it is in any way repugnant, it is invalid from the beginning. So the Palestine Supreme Court, sitting as High Court of Justice, is willing to scrutinize ordinances for compatibility with the mandate and indirectly with the Balfour Declaration. And the court says it is an extremely inconvenient conclusion because it enables the best intentioned ordinances to be held invalid because of some repugnancy to a document not easy to construe and throw the responsibility of deciding these matters on courts of law. However, there it is in black and white, and we have to give judgment in accordance with the ordinary meaning of words. Can you imagine? And this judgment is appealed to the Privy Council, and here the Privy Council makes two important points. First of all, it says that this judgment of the Palestine Supreme Court can be appealed to the Privy Council. And second, the Privy Council in London approves of the legal construction that the Supreme Court of Palestine has offered. So it was the right and the duty of the court to examine the terms of the mandate and to consider whether the ordinance was in any way repugnant to those terms. I will mention three other judgments of the Palestine Supreme Court. First one is about the application to the High Court by Palestinians who refuse to who oppose to the inclusion of the acronym Aleph Yud for Eretz Israel on stamps, on official stamps of the mandatory power, and the court rejects their petition. They say adding the Hebrew title of Palestine, Eretz Israel, runs against the idea of equal treatment. There's one title, which is Palestine, so Palestina, and Eretz Israel should not be included, or even the acronym should not be included. But the court says, no, this is not an ordinance. This is not a legislation. It is an administrative act, and these acts are not reviewable. So you see the court retracing from its original commitment to review legal acts as under the mandate. And you see the reason. The court says matters of sentiment or politics could not come within the scope of the authority of the High Court unless expressly included in some instruments of law. Kind of political question, or the question that raises communal sensitivities. The court doesn't want to get involved. Another, I think, I included in this presentation, I think an interesting decision of the court relates to a local ordinance of the Council of Tel Aviv, requiring all shops and factories owned by Jews to be closed on the Sabbath. This was found void as contravening Article 15 of the mandate, incorporated in the order in Council. Article 15 that ensured freedom of conscience, non-discrimination on grounds of race, religion, language. Maybe this is the cause, this is the root of the idea of Tel Aviv as an unstoppable city, right? Ir lelo hafsaka. And finally, I think a very important and famous case, Rosenblatt versus the Register of Lands in Haifa, where Rosenblatt and others seek to void the land transfer regulation of 1939 that incorporated in the law of Palestine the White Paper of 1939 that prohibited the sale of land to Jews, the court avoids or evades its obligation according to the mandate and according to Article 89 of the Ordering Council of 1922 by saying, well, you know, this was a regulation. This was not an ordinance. And the commitment was to ensure that ordinances are in compliance with the letter of mandate. This is simply a regulation, so we will not examine that. This is regarded by the Israeli Supreme Court after independence as a decision that should be ignored. The position of the Israeli Supreme Court consistently is that all orders in council, all regulations, and all other acts are should be examined in light of the letter of mandate. And here I want to acknowledge my conversation with my former PhD students, now my colleague Ziv Borer, who is doing research on this last point. Now, the third and final part, which for me I think is the most significant one, and this is the significance of the declaration for the establishment of the State of Israel. This goes back to the question of self-determination and whether self-determination was in 1922 when the mandate was promulgated, whether the principle of self-determination was a legal right, was recognized as a legal right. Because if self-determination was at the time a legal right, self-determination of peoples, then there will be support for the Palestinian claim that the community in Palestine at the time, which consisted of about 90% Arabs, had the right to statehood. Now, it is generally understood that at the time, the concept of self-determination was a principle that had political implications, but it was not recognized as a legal right under international law. But, and here's the important but, there are those scholars who argue that although the principle of self-determination was not recognized as a legal right in 1922, it was specifically recognized as such in Article 22 of the Covenant of the League of Nations with respect to the communities, the certain communities formerly belonging to the Turkish Empire who have reached a stage of development where the existence as an independent nation can be provisionally recognized. And their wishes must be a principal consideration in the selection of the mandatory. So there's an argument that for those communities that previously were under the rule of the Ottoman Empire, they had the right to self-determination, a legal right to self-determination, which suggests that for those, if that argument is accepted, the insertion of the Balfour Declaration, the commitment to the Zionist effort in Palestine, was a crucial step in order to negate the recognition of the right to self-determination for the community in Palestine. Recall that the mandatory, the concept of the mandates under the League of Nations provides that what counts is the specific letter of mandate that is given to the mandatory power. And so the degree of authority, control, administration is provided in the specific letter. And the letter of mandate is not challenged and by other countries and is generally accepted as reflecting valid law. So the result is that the text of the declaration, with its reference to the Balfour, the text of the mandate, with its reference to the Balfour Declaration, serves to undercut the more general claim for self-determination for the previously Ottoman communities. And so this, I think, helps the claim that in 1948, Israel is able to claim sovereignty over those parts of Palestine that it controls at the end of the war. So here there are three legal dimensions of the Balfour Declaration. Thank you very much.